Hi, my name is Dorian Eden, and I'm a family law attorney with the law firm of Tiffany Bosco. I have been asked by the Arizona Center for Divorce Education to provide the top 10 questions and answers that I am asked frequently by clients or potential clients. One thing to keep in mind, I am providing this information solely for educational purposes. There is no attorney-client privilege that is created here, and I'm not giving you any legal advice. Certainly, if you have specific questions relating to your specific situation, feel free to contact me or another family law attorney to address those issues. So the first question that most people want to know about involves the custody of their children. How do they get sole custody, or how are they awarded sole custody of their children? In the court's eyes, the court has to determine what is in the children or child's best interest in terms of who should have decision-making power over the children. And that's all that custody actually deals with, is decision-making power. And by decision-making power, we're talking about big decisions, where the children are going to go to school, what non-emergency medical treatment they're going to undergo, what religious upbringing they're going to be involved in, things like that. It doesn't deal with issues such as, should my child get a haircut? Those day-to-day issues, the presumption is that whoever has the children with them at that time can make the decision. Sole custody, as I said, is only decision-making power. And unless there's an issue with fitness, meaning one parent is unable to properly parent because of abuse and neglect issues, drug abuse, is in jail, is absent, doesn't have a good relationship with the children, there's been domestic violence, things like that are reasons why a court may award one parent sole custody. However, the presumption is, in most cases, that joint custody is appropriate, meaning the parties share in that decision-making power. The second question that I often get is, does joint custody mean that my children are going to be with me half the time? And the answer to that question is no. Again, joint custody or custody only relates to decision-making power. Children's access or a parenting plan is what governs where the children are going to be and when. You can have an equal access plan where the children are with both parents 50% of the time, which can be as often as a week on, week off. It can be every couple of days they switch households, or you can have the very generic every other weekend, one night during the week access plan, or anything in the middle. What the court is looking at, again, is what's in the children's best interest. And if there's going to be an equal access plan or something close to it, is it logistically feasible? Do the parents live close enough together that they can do that? Is it in the kid's best interest to be going back and forth between the parents every few days or every week or so? There's a variety of factors that the court has to consider in terms of making these decisions regarding custody and access, but in general, joint custody does not mean that the kids are going to be with both parents 50% of the time. The third question that I get asked a lot is about child support. How much child support am I going to receive, or how much child support is the other parent going to have to pay? And the answer to that question is pretty easy. It is whatever the child support guidelines say the child support amount should be. Child support is predicated upon each parent's income and how much parenting time the parents each have. There are other things that get calculated into the equation as well, such as who pays health insurance for the child. Are there any extra education expenses, such as private school tuition or daycare expenses? Is there a special needs child? Things like that get factored in as well. But at the end of the day, whatever the child support guidelines say child support is going to be, that is primarily what it's going to be. You can deviate upwards or downwards sometimes, but the court has to find that that's in the child or children's best interest. I can say that child support and the guidelines get revisited every few years, and effective January of 2010, the child support guidelines are apparently going to be substantially modified. The fourth issue that I often receive questions about relates to spousal maintenance. Do I qualify for spousal maintenance, or is my spouse going to qualify for spousal maintenance? Am I going to have to pay spousal maintenance? Spousal maintenance is also controlled by guidelines, but these guidelines are very loosely enforced, meaning there's no straight calculation that you can do that the courts follow. There are rather a list of factors that the court has to take into consideration when deciding whether or not one party is a candidate for spousal maintenance, and if so, what is the appropriate amount of spousal maintenance and how long is the spousal maintenance period going to last. Most of the time, spousal maintenance is paid for a period of time to allow the lesser earning spouse to get to a position where they can then be self-sufficient. Some of the things that the court takes into consideration are the length of the marriage, whether or not one spouse put their career on hold to better the career of the other spouse, if one parent was staying home with children, if there are health concerns, if somebody has been out of the workforce for a period of time, what was the financial expectations or what was the financial circumstances of the parties during the marriage. Those, amongst other things, are what the court looks at when deciding whether or not someone is a candidate for spousal maintenance and then determining the length and duration of spousal maintenance. Now, the fifth question that I'm often asked is, if there is spousal maintenance put in place, how do I terminate spousal maintenance? Or how do I modify it? And the answer to that one is that spousal maintenance can be set as non-modifiable, either in amount or duration or both, meaning you can't ever change it, or it can be modifiable. The only way it can be non-modifiable is if the parties agree to do that. If otherwise, it is presumptively modifiable. And as long as there has been a substantial and continuing change of circumstances, then spousal maintenance will always be modifiable. So if one parent or party, has a substantial change in income or change in circumstance, somebody's living expenses have increased or decreased dramatically, as long as there is a continuing change of circumstances, you may be able to modify or terminate spousal maintenance. Generally speaking, temporary unemployment does not give rise to a modification of spousal maintenance. One other thing to keep in mind is that spousal maintenance will terminate upon the death or remarriage of the person who is receiving the spousal maintenance, or the person who is paying the spousal maintenance. It would terminate upon their death as well. It's a good idea to have a life insurance policy in place on the payor spouse, especially if you are the payee, because if your ex-spouse dies and you are entitled to spousal maintenance or you have an award of spousal maintenance, you want to make sure that that money continues to come in even after their death.